C. Richardson, The English Jury under Angevin Kings 94, 1960, Jews' liquidation of land obligations broke down rigidity of feudal land tenure, and facilitated transfer of land to a new capitalist class. Footnote 15. Cf. 1F Pollock and F.W. Maitland. Supernote 3 at 469, alien to English law for creditor, not in possession of land, to have rights in it. The Pharisees worked with the Normans under the blessing of the Pope of Rome, and its Roman civil municipal codes, also as to establish this weapon of socio-economic change, that tore the fabric of the society of the Anglo-Saxon/Celtic peoples. These are words of Miss Shapiro as they appear in the Georgetown Law Journal. The aggressively warring nature of that Babylonian Talmudian-based code of Pharisaical conduct is not in question among that circle of scholars. It is a body of slave/master codes. It tears at the fabric of that society which it targets. The shutter is a corruption of the word star, and refers to the famous Star Chamber courts. The name Star Chamber has been thought to be, because the roof was originally studded with stars, because the Jewish covenants, called stars or stars, right parenthesis, were originally kept there. Bovier's 1860. Star or stara, the old term for contract or obligation among the Jews, being a corruption from the Hebrew word sheter, a covenant, and Blackstone conjectures that the room in which the chests were kept was thence called the Star Chamber. Star Chamber, a court which originally had jurisdiction in cases where the ordinary course of justice was so much obstructed by one party that no inferior court would find its process obeyed. In the reign of Henry VIII and his successors, the jurisdiction of the court was illegally extended to such a degree, especially in punishing the king's arbitrary proclamations, that it became odious to the nation, and was abolished. Black's Fifth. These courts of Pharisaical commercial master/slave codes became heinous in part for their secret proceedings, and their infliction of cruel and unusual punishments, but they were abolished. They were the essence of the so-called equity jurisdiction. It was all run by chancery priests, and referred to indeceptively as courts of equity, the only thing being equal about them is that all conquered slaves thereunder are treated more or less equally. Courts of Chancery is a more honest name, as it was great chance taken to go before such. The whole of equity jurisprudence prevailing in England and the United States is mainly based on the civil law, so says Bovier's Law Dictionary of 1868. Civil law is from Rome. There was no equity jurisprudence in England prior to the Norman Conquest. The Norman Conquest had the solemn approval of the Pope of Rome according to the Encyclopaedia Britannica. Other sources confirm the Roman Pope's support and blessing. The conclusion to reasonable men is that the Normans' war of aggression was jointly backed by the Christ-killing Pharisees and the Pope of Rome, so as to forcibly impose the Roman civil/municipal codes of Babylonian-Talmudian base master/slave relations. These were mere tools for slave control which was early imposed by evil men with great influence within the Pharisaical and Catholic religious communities. Any truly godly spirituality which may have existed within either of those religious organizations was most assuredly bound and gagged by the more powerful forces of evil therein at the times of the Norman Conquest. As at the Crusades, as at the Inquisition, these entities have very bad track records. Evil men aggressively made religious war against the Christian/common law, Anglo-Saxon/Celtic peoples of England in 1066. The Babylonian Talmud was completed well before the Norman Conquest of 1066. It's all the same basic master/slave commerce form of code of human conduct. It all treats living breathing people as merchandise in commerce, to be bought and sold as those slaves, and the souls of men as referred to in Revelation 18:13. This entire body of codified human conduct is also amorally lacking in fidelity to the supreme laws of love of neighbor from YHVH as taught by his son Yeshua, as to be clearly a policy of the synagogue of Satan as referred to at Revelation 2:9 and 3:9. It is easy to summarize that this is that precise same code of human conduct, of which the Pharisee money changers were using to corrupt the temple in Jerusalem, and of which Christ Jesus overturned their tables and drove them out of his Father's house with the whip. It is easy to summarize that this is the code of conduct upon which the Pharisees moved to whip up the mob into such a fervent state of anarchy as to abort due process of law, and to have Yeshua the Christ lawlessly nailed to the cross, or stake. This code of conduct embodied within the Babylonian Talmud is very large, but it contains specific portions which are designed to tear at the fabric of the society which is its target. These are the words of Miss Shapiro, as set forth in the Georgetown Law Journal. This is not the wording of anti-Semitic right-wing extremists. Miss Shapiro's term tier is specifically used to denote that process which obliterated the fabric of society, as it had existed prior to that war of aggression. It would seem reasonable to conclude that this is a code of human conduct based on terrorism. Certainly the word tier seems related to terrorism. Certainly the Anglo-Saxon/Celtic Christian people were greatly fear-inspired by the forcible imposition of this Babylonian Talmud-based code of human conduct. The wording of Mishnah reasonably seems to be an acknowledgement that terrorism was used by the Normans and the Pharisees who call themselves Jews as a matter of policy under that code of human conduct known as the Babylonian Talmud. This entire body of Roman civil law is based upon contracts, and it was early incorporated into what was known as English law merchant, which many fine scholars have confused as being a true part of the English common law. Such happened only after corrupting influence of the Norman conquest. Contracts are only enforceable in courts of so-called equity. Equity jurisdiction was allowed to enter into American jurisprudence by way of Article 3 Section 2-1 of the United States Constitution. Such was a slap in the face of Christ Jesus, and much evil has worked its purpose in this land by way of that compromise of godly principles. However, equity is purged from all of its authority to adjudicate anything, if proper due process of law is invoked, as such process is set forth in Becontheatas v. Westover. This modern essence of law allows Americans to free themselves by due process of law from the Babylonian master/slave jurisdiction of so-called equity.